Hello, and welcome back to Coin Lady channel. I am certainly not alone in saying this, that the SEC is a gross agency that is tremendously overreaching, and today I have some news that I think all of you XRP holders out there will find rather satisfying. And they consider themselves to be above the law. Their baseless assertions are indicative of the inflated attitude of entitlement displayed by these folks. In the case of SEC versus Rebel, of course. Case, but also other cases involving cryptography. They have been flatly refusing to approve a Bitcoin ETF in any form for well over a decade. Aside from the unusual circumstances of the library case, they have been soundly defeated this year in case after case by judges and numerous crypto trials. We weren't quite successful in the remedy phase of the library case, but we did get close. Not everything went horribly wrong. There is something I don't feel like explaining. I've addressed this topic here before. But the point is that the SEC has been soundly defeated by virtually every crypto advance you see in terms of case law. And here's another loss I'm going to tell you about, and this one has nothing to do with crypto. They appear to be overreaching in every area. However, it is only superficially unrelated to cryptography. Allow me to elaborate on what I mean. I'd also like to provide you some insight from Shark Tank's Mark Cuban and attorney John Deaton. Furthermore, despite this, XRP adoption will continue regardless of what the SEC wishes to happen. I'll explain why the news that 30 countries, or more than 15% of the world's countries, may use the Ripple central bank digital currency platform made headlines in the crypto space recently. But before I go any further, I should state that I have no training in law or finance. Please do not take anything I say as professional advice. You should not make any financial decisions based on the content of my YouTube channel. I merely like making videos there about cryptocurrency related issues in my spare time. Okay, so the lawyer James Murphy, aka Meta Wallman on X, previously Twitter, is responsible for my discovery of this first topic. A 3-judge panel of the DC Circuit just rejected an SEC order for being arbitrary and capricious, he said. GBTC is a grayscale Bitcoin trust, so it is only available to accredited investors in the United States. However, 2 of the 3 judges are currently considering a case brought by Grayscale that seeks to invalidate the SEC's denial of Grayscale's bid to convert GBTC to a spot Bitcoin exchange-traded fund. They plan to transform it into a spot Bitcoin ETF, which would be tradable by anybody with an account on the New York Stock Exchange, NYSE, or the National Association of Securities Dealers, NASDAQ. You can probably guess what it means. Institutional and individual investors who previously had no plans to participate in cryptocurrencies can now do so in record time. They think of the 2 words together, capricious and arbitrary. And consider the outcome of the SEC versus Ripple case. That's either exactly what the judge meant when he stated the SEC is participating in a faithful or lack of faithful allegiance to the law, or close to it. You can see why I like working with you, but these are some pretty strong things to use against the SEC. I'm not sure how long this has been going on, but there seems to be a toxic atmosphere at the SEC that's being encouraged from the top down. They undertake extreme measures, including wholesale devastation, all for the sake of pursuing the crypto case, which falls under Landgraf's authority. In a word, it's disgusting. The following was written by Eric Abel Kunis, Bloomberg's senior ETF analyst, and retweeted by attorney James Murphy. DC Circuit Court ruled that the SEC's ruling was arbitrary and capricious, which is the same wording Grayscale used in their lawsuit, claiming there is no relation to Bitcoin. Nonetheless, this defeat does demonstrate that the SEC may be defeated. Yeah, well, we already know the SEC can lose. They just lost the biggest crypto case they could have lost, XRP being deemed not a security, so they definitely can lose. And they're going to continue losing at an increasing clip here because they put out so many crypto-related cases on bogus foundation, and it takes so long for these things to get to be, to go through the judicial process. That's why they've had case after case, and it won't finish until 123 years from now, or whenever it does. This is just the chutzpah of it all. and they had a whole batch waiting to be resolved under the same false premise. What follows is a cascade of financial disaster, or at least that's what you should expect. Furthermore, they will suffer complete and utter losses in every single instance. But it's very evident that no matter what, the person you're taking with you will not be accepted. Interesting. Second, this judgment was made by one of the 3 judges who are colorblind. Case. Thank you, whomever you are at JBSDC, for spotting Justin's X-rated error. The same grayscale language aside, Eric also noted here that the name arbitrary and capricious would be perfect for a podcast about the intersection of law and regulation. In light of the recent Enema reporting concerning the grayscale case, it's evident that the courts agree with the Enema reporting that the SEC's actions are totally improper, as well as being totally unreasonable and unjust. There they discuss the SEC's actions and the direction the agency is taking in its litigation. Because of this, and because the same judges will be considering both sides of this case, I just can't see how Grayscale doesn't emerge victorious in the end. In a significant way. Reason being, well, here's why us and crypto in general, including, of course, each and every one of us in XRP community, we were around long before most of the world's major financial institutions adopted cryptocurrencies. They will arrive whether or not the SEC approves. If the conference has to be dragged kicking and screaming, so be it. Once that occurs, it's like throwing open the floodgates, then every institution will rush in. Even if you're only interested in XRP as a secondary asset like I am, money will still flow into Bitcoin first and then cycle across crypto. This is true even if you're simply talking about being a Bitcoin spot ETF. That's just how it operates, though. And it will attract more people, and I expect there will be an XRP spot ETF in the future. Here's a tweet by Randall Nooner that doesn't involve him. And he was emphasizing something I had expressed in a video only the day before. My video was 10 minutes long, the one he has here is only 2. However, the interview with Ginza lasted only 10 minutes. In addition, he was recently questioned in regard to the SEC versus Ripple lawsuit and related matters. And he was evading inquiries, clearly uncomfortable. This made me happy to see. He probably fears giving interviews, but avoiding any kind of public presence would look far worse. He's forcing himself to go public, but I'm sure he's dreading it because he knows the SEC is going to grill him about their tragic loss. Therefore, there is this Bloomberg video that was shared and then ran by Nooner, who, by the way, is not a fan of XRP. He sees the problem for what it is. According to him, Gary comes out as bitter and defeated. He's implying that the other commissioners have some real input now that they've opposed his methods before. In this, the rare case where I agree with something Rand Nooner said regarding XRP, he is obviously weakened by the XRP ruling. Yes, spot correct. The Shark Tank star Mark Cuban just retweeted that. And he added that he always refers to token holders as investors. Although he recognizes the fallacy, he can use it to his advantage. Before continuing, I should mention that I often refer to my XRP purchases as investments. I identify as a guy in cyberspace. Right? Therefore, I believe a different standard should be applied when discussing Kim Jong-Ginza, the former head of the SEC, in this context. I'm just using everyday language here. Kim Jong-Gensler must be careful with his remarks because they carry weighty connotations. For my part, I'm just making a statement about what I own and hoping will be worth more in the future. However, the ramifications change when you refer to it as an investment from a legal standpoint. It's not the same thing if you're Kim Jong-Gensler and you're leaving the darn nation and you use the phrase in plain terms like you and I do. He is aware that his claims are not true from a legal standpoint, yet he insists on spreading the false impression that everything is a giant gambling operation. When discussing cryptography, he wants to portray XRP gambling in this or that cryptocurrency as something shady and repulsive, when in reality it's just a bunch of people putting bets. He has long since stopped being convincing. The Howey test doesn't include such a requirement. But that's the tack he's been adopting up until now. Simply said, it doesn't work. No one is interested in what he's selling. Anyway. Moreover, Mark Cuban adds, prompting the inquiry as to which tokens are still receiving active enhancement, support, and promotion. That is to say, which are functioning as a joint venture. Since crypto investment has dropped over the previous year, the numbers could show that many tokens are doomed to fail because their common enterprise and connected people have ceased their efforts. Sorry, I don't have any numbers to share. Do we have any way of finding out? So, when discussing the Howey test's common enterprise criteria, it's reasonable to point out that if hello, my dog is beneath my desk, and she's moving, please keep still annoyance. I appreciate it, honey. I truly apologize. My annoyance spends nearly all of her time behind my desk, where she is content to be silent while I record. She does well. I truly apologize. Anyway. You may make an argument that the smaller an entity is, the less of an impact it has on the organization as a whole, which could have implications for how it is developed or some other aspect of the enterprise. Even then, and this is the crux of the matter, you must examine individual transactions in light of the Howey test. And I just wanted to call it out because attorney John Deaton retweeted that from Mark Cuban and said, "Excellent point," so I thought I'd mention it. For the same reason, I doubt the SEC will prevail if they file an appeal against the Torres' ruling decision. Judge Torres did not rule on whether Ripple, all other XRP holders, and the XRP ecosystem, including exchanges, operated as a single entity in regards to automated sales through exchanges. For the reason that the third Howey factor wasn't met. The SEC had a tougher time meeting the common enterprise requirement. The judge also ruled against the use of expert testimony. Finally, we filed thousands of affidavits from platform users who bought XRP for reasons other than investment. If the SEC prevails on appeal with respect to the third criterion, the matter will be remitted to Judge Torres for her consideration of the remaining two considerations, where she will likely conclude that they are also wanting. Dead on. Even if an appeal succeeds, it will be on the fundamental aspects of Judge Torres's Howey test ruling. If that's the ruling, she'll base her decision on the additional evidence if it comes back to her. And you already know that she will reach the same conclusion. Oh, they won't let her throw away all this money. This accomplishes the same thing in practice. It's lovely no matter what. I love how screwed the SEC is in this situation. There was also the possibility that more than 30 countries, or 15% of the world's countries, might use the Ripple CBDC platform. So, consider this XRP-provided citation. I'll be brief, Darren, because the rest of the world doesn't give a damn what the SEC says, but I just wanted to point that out. And it keeps on going strong. And XRP is a transitional currency. And it has the most liquidity of any cryptocurrency, making it ideal for this use. And so XRP Darren pointed out that there is a recent interview, in which James Wallace, an employee of Ripple, said, "Hey, we're already working with 5 central banks to produce central bank digital currencies that have been officially stated. We're also working with a comparable quantity we haven't publicly acknowledged yet. That's 10 in a flash." Then he adds, "And on top of that, there's another 20 that we're talking to." If all of these banks joined forces, it would mean that more than 15% of the world's central banks were using Ripple's central bank digital currency platform. This platform does not feature XRP directly, but it will serve to improve the velocity of money. There will be more financial transactions if people don't have to exert as much effort or pay as much in fees when doing so. I mean, that's the whole point. And the most liquid crypto is the most liquid non-jurisdictional, which is why XRP is so well suited to serve as a bridge. Because of this, it appears that it will once again be able to reach the United States. Nevertheless, I am not a financial advisor, and you should not purchase or sell anything based on my advice. Please like and subscribe my channel. See you later, bye.